judgment in the matter of Samuels versus Birmingham City Council.
Lord Carnworth will explain the decision of the court.
Mrs. Samuels and her family of 4 children were given notice to quit the home which she held as an assured short-hold tenant because of her failure to pay the rent. She applied to the council for assistance under the homeless persons legislation. The council had to decide whether she was intentionally homeless. In deciding that issue under the Homelessness Suitability of Accommodation Order 1996, the council had to consider whether the accommodation was, quote, affordable, taking account on one side of the financial resources available to her, and including social security benefits, and on the other, her other reasonable living expenses apart from rent. In a code of guidance issued in 2006, the Secretary of State had recommended, quotes, that housing authorities regard accommodation as not being affordable if the applicant would be left with a residual income which would be less than the level of income support applicable in respect to the applicant, or would be applicable if she was entitled to claim such benefit. The guidance said nothing in terms about comparison with benefits for children. Now, the council decided against her that she was intentionally homeless and that her rent had been affordable, on the basis that the shortfall in rent, as compared with her income, could have been met by greater flexibility in the household budgeting. Her appeal to the county court and her onward appeal to the Court of Appeal were dismissed. However, the Supreme Court now unanimously allows the appeal and quashes the council's decision in a judgment given by myself. Consideration of the applicant's reasonable living expenses requires an objective assessment, not simply the subjective view of the case officer. The lack of a specific reference in the code to benefits other than income support does not make them irrelevant. Such benefit levels are not generally designed to provide a surplus above subsistence needs for the family. They are therefore useful in assessing what is reasonable by way of living expenses, at least as a good starting point for that exercise. In this case, the review officer had asked the wrong question. The issue was not whether there was sufficient flexibility to enable her to cope with the shortfall between rent and benefits, but what were her reasonable living expenses other than rent, having regard to both her needs and those of the children. Her total expenses, as shown in the schedule provided by her solicitors, were well below the amounts regarded as appropriate by way of welfare benefits. It was difficult, therefore, to see by what standard they could be regarded as unreasonable. The review decision would therefore be quashed. Although the court had not been asked to remake the decision, it expressed the hope that on reconsideration the council would be able to accept full responsibility for the family under the homelessness legislation.